Its long title reads, among other things, that it is an act, I'm quoting, to provide for the regulation of the Uganda People's Defence Forces in accordance with Article 210 of the Uganda Constitution and for other related matters. It is a specialized court in the sense that it was created to exercise jurisdiction over specified matters relating to offences created by the UPDF Act, committed by members of the military forces and persons who aid or abet such offences. In short, to administer military justice in Uganda with jurisdiction to handle offences specified in the Act, mainly for penal and disciplinary purposes. The General Court Martial was therefore established as a specialized court of the military forces. On the other hand, the Constitution also establishes courts of judicature empowered to exercise judicial power with various jurisdictions under Article 129 of the Constitution, which states that the judicial power of Uganda shall be exercised by the courts of judicature, which shall consist of A, the Supreme Court of Uganda, B, the Court of Appeal of Uganda, C, the High Court of Uganda, and such subordinate courts as Parliament may by law establish, including Cadi's courts for marriage, divorce, inheritance of property, and guardianship, as may be prescribed by Parliament. 2, the Supreme Court, the Court of Appeal, and the High Court shall be superior courts of record and shall each have all powers of such court. And 3, subject to the provisions of this Constitution, Parliament may make provisions for jurisdiction and procedure of the courts. Both the courts martial and the courts of judicature therefore have their origins from the Constitution, save that while the Constitution directly sets up the courts of judicature under Article 129, the courts martial are set up by an Act of Parliament as mandated under Article 129(1)(d) and 210 of the Constitution. The criteria for appointment of members who sit on the General Court Martial set out under Section 195 in the revised version of the Laws of Uganda 2023 of the UPDF Act is that they should essentially be army officers, with the chairperson not being below the rank of a lieutenant general. Save for the chairperson of the court of the Court Martial Appeal Court, who is required to be an advocate, qualified to be appointed as a judge of the High Court. Legal qualification is not a basis for appointment on the General Court Martial and the other military courts set up under the UPDF Act. In contrast, under Article 143 of the Constitution of Uganda, persons qualified for appointment as judicial officers to the courts of judicature as established under Article 129 of the Constitution of Uganda, must have legal qualifications. It is to be noted that both the General Court Martial and the Courts of Judicature, particularly the superior courts, under the respective laws that govern them, as well as the penal laws, either in the exercise of their original or appellate jurisdiction, are empowered to pass the death penalty, which is the maximum punishment a court of law would pass. It is also noted that under Article 123B of the Constitution of Uganda, the Director of Public Prosecutions, who is the officer charged with the criminal trials in the General Court Martial, unlike in the case for courts of judicature, is not controlled by the Director of Public Prosecutions. The interests of justice and fairness require that any court that is empowered to pass a penalty for a penalty as serious as a death penalty, or even, I dare say, imprisonment, should be presided over by competent persons with legal qualifications. The criminal prosecutions conducted before such courts should ideally be controlled by the Director of Public Prosecutions. This would be a safeguard for a fair trial envisaged under Article 28(3) of the Constitution of Uganda. In addition to the International Covenant on Civil and Political Rights, to which Uganda is signatory, and all other international human rights instruments, binding or persuasive, which have been ably highlighted in the other judgments to this appeal. In my considered opinion, it would not matter whether in actual fact, that is de facto, the members appointed to sit on the General Court Martial, in the wisdom of the appointing authorities, do possess the legal qualifications to be competent to adjudicate criminal matters, especially those attracting heavy penalties. As long as the UPDF Act that creates the General Court Martial does not expressly include legal qualifications as a requirement for appointment to the General Court Martial, that is de jure, the competence and capacity of that court to handle criminal trials would still be questioned, as is being done in this appeal. This is based on the cardinal principle in our legal system that justice must not only be done, it must be seen to be done. The General Court Martial would only be competent to adjudicate over criminal matters of not only civilians, but also military persons, if it were a court of law with the requisite structures to conduct a fair hearing, as envisaged under Article 28 of the Constitution of Uganda. there can be no fair trial as envisaged in Article 28(1) of the Constitution in an incompetent court. It is in that regard I would, with respect, not agree with the appellant's contentions that the General Court Martial is a court of competent jurisdiction to hear criminal matters. In its present state, the General Court Martial, though lawfully set up by an Act of Parliament, deriving such powers from Article 129(1)(d) of the Constitution, is in its present form competent only to handle matters relating to discipline of members of the armed forces. The result, based on the above, and in addition to the reasons, decisions, conclusions, and recommendations for legal reforms stated in the lead judgment, which I associate myself with, I would conclude that this appeal fails, save for the issue regarding the establishment of the General Court Martial as a court of law. I would dismiss it to that extent and allow the cross appeal. I would award the course of this appeal to the respondent in this court and in the courts below.
Thank you, my lord. I propose we take a 10 minutes health break.
Yes, my lord.
Yes, because 200 pages will take us up to midnight, I think. So, okay. So 10 minutes break, health break, yes.